Hey guys, it's me again, Attorney Al Jumrani, and you are watching the House of Law. This is part 2 of Land Titles and Deeds, the 2024 edition. Una sa lahat, gusto ko magpasalamat sa lahat ng mga nanood ng part 1 ng Land Titles and Deeds Lecture, the 2024 edition. Sana ay marami kayo natutunan. Sana din ay napukaw ang inyong excitement or ang inyong pagkauhaw sa knowledge about land titles and deeds dahil sa part 1. Dahil kung may mga tanong kayo or meron kayong mga gusto pang maliwanagan, this is the continuation of that part 1 of land titles and deeds lecture. So sa mga ngayon pa lang nanonood, kung hindi nyo po napanood ang part 1, you can watch part 1 in the link above or in the link in the description box below. Pero mamaya na, tapusin nyo muna itong video na to. Or better yet, panoorin nyo muna yun and then bumalik kayo dito. Basta make sure you watch both videos, okay? So anyway, let's proceed. So in this video, we will be learning about reversion of lands, subsequent registration, particularly through sale and inheritance, due diligence in acquiring real property, particularly itong tinatawag na mirror doctrine. Also, we will be talking about recording of encumbrances, cadastral registration, registration of unregistered lands, and assurance fund. O diba, exciting? So kaya wag na natin patagalin ito. Simulan na natin sa reversion. So ano nga ba itong reversion? Well, simplihan natin. Ang root word ng reversion is revert. Ibig sabihin, balik or pagbabalik. So the idea suggests that the land which was previously registered to a private person will be reverted or will be returned to the public domain. Bakit ibabalik sa public domain kung narehistro na sa isang pribadong tao? Well, remember the Regalian Doctrine, which I lengthily discussed in part 1 of this video. It states that all lands of the public domain belong to the state. And of all the classes or types of lands of the public domain, one of them, the public agricultural lands, can be alienated and disposed for private ownership. So bago narehistro yan sa isang pribadong tao, naging parte yan ng public domain. So ang reversion ay isang remedy o remedyo ng Estado para ibalik ang isang naging pribado ng lupa or lupain sa Estado. Okay? So what could be the grounds? Well, maraming grounds yan. No? So it could be because the procedure was irregular. So dalawa yung procedure, di ba? Free patent as well as judicial confirmation of imperfect titles. Now, aside from the irregularity in the procedure, there could be fraud in the application. So fraud kasi merong deception, merong panloloko or panlilinlang. Like the applicant made it to appear that he was qualified, but in reality he was not. Okay, so kaya pwedeng ipa-cancela yung titulo ng registered owner tapos maibalik yan sa public domain. Now, in or under Section 101 of CA 141 or the Commonwealth Act 141, the Public Land Act, sinasabi doon na all actions for the reversion to the government of lands of the public domain or improvements thereon shall be instituted by the Solicitor General or the officer acting in his stead in the proper courts and in the name of the Commonwealth, now the Republic of the Philippines. Now, take note na may mga nagfa-file ng petisyon sa korte or action ng mga private individuals. So it could be through an action for reconveyance na na-discuss ko rin in part 1 or an action of quality of title. Their intention really is to cancel the title, to divest the registered owner of the property. But then, sabi ng Supreme Court, kung ang ultimate result will be for the land to be untitled and returned to the state, dapat ang gobyerno ang mag-initiate niyan. Kasi nga that will be treated as an action for reversion. The private person who filed that action will not be entitled to the land even if the petition or the complaint is granted in favor of the complainant or the petitioner, no? Kasi nga halimbawa na-prove naman talaga sa trial na the registrant is not entitled to registration because either the procedure taken was irregular or because of fraud. Pero hindi naman mapupunta kay plaintiff kasi in the first place hindi rin niya na-establish sa government halimbawa, hindi niya na-establish in a proper proceeding halimbawa na siya ang entitled kasi nga nagkaroon ng proseso na bigay naman dito sa defendant. I hope you get what I mean. So kaya sabi ng Supreme Court in Esguerra versus Spouses Ignacio, in an action for reversion, the pertinent allegations in the complaint would admit state ownership of the disputed land. At yun yung default, di ba, because of the Regalian Doctrine. Hence, where the plaintiff in his complaint admits that he has no right to demand the cancellation or amendment of the defendant's title because even if the title were canceled or amended, the ownership of the land embraced therein or of the portion affected by the amendment would revert to the public domain, then the action is for reversion and the only person or entity entitled to relief would be the director of lands, to say the state. Okay, so I hope you get that. All right. Now, as a rule, reversion can be filed anytime. This is because prescription does not lie against the state. Ibig sabihin, ang estado pwede niyang bawiin yung lupang yan kahit ilang taon na ang lumipas. 100 years pa yan, it doesn't matter because the state is not affected by prescription. And besides, under the Regalian Doctrine, the state really has the right to take back what was unlawfully or irregularly taken from it. However, that rule is not absolute kasi meron pong nakakatalo dyan sa imprescriptibility of actions filed by the state, and that is laches. Kaya in the estate of Jesus Huico versus Republic, a 2007 case, sabi ng Supreme Court, while the general rule is that an action to recover lands of public domain is imprescriptible, said right can be barred by laches or estoppel. Section 32 of PD 1592 recognizes the rights of an innocent purchaser for value over and above the interests of the government. So ibig sabihin, the imprescriptibility of an action for reversion can be defeated by laches as well as the rights of an innocent purchaser for value. Now, in this case, it was over 14 years before I'm just trying to remember and hopefully my memory serves me right. It took over 14 years before the state filed the reversion. Paano naging 14 years at kailan binila or kailan ni kinompute or ni recon yung 14 years? Well, from the time that there was a reason or a cause of action to file the reversion, no, the petition for reversion, na-delay for for no apparent reason, na-delay yung pag-file na action for reversion. Meanwhile, the property has already changed hands from the time or from the original registrant, tapos napunta pa sa iba, and then finally, nagkaroon na ng innocent purchaser for value. So sabi ng Supreme Court, OA na yan. 14 years, masyadong matagal. Matagal nyo na alam, matagal na kayong sinabihan na may irregularity, you could have immediately filed it, but you took your time, you slept on your rights. Kaya sabi sa Supreme Court, hindi na po pwede, lalo na magkakaroon ng serious damage doon sa nakabili or the present owner who under the law was an innocent purchaser for value. Okay, so kaya ginamitan ng laches as well as the presence of an innocent purchaser for value yung kaso ng estate of Jesus Huico versus Republic. So what is the meaning of laches? For the benefit of everyone, laches is the failure or neglect for an unreasonable and unexplained length of time to do that which by exercising due diligence could or should have been done earlier. It is negligence or omission to assert a right within a reasonable time, warranting a presumption that the party entitled thereto has either abandoned or declined to assert it. Okay. So now let's go to the exciting part, and this is subsequent registration. So na discuss ko sa part 1 yung original registration, meaning yung first time na marirehistro sa pangalan ng isang pribadong tao ang isang lupain. Now this time, let's talk about subsequent registration through the most popular or common modes, and that is by sale and by inheritance. Tinatawag natin siyang subsequent registration because kasunod siya ng original registration. Okay, so here are the steps or the procedure for subsequent registration. Now, I want you to always remember that a certificate of title is just an evidence of ownership. It is not a mode of acquiring ownership. Just because you have a title doesn't make it does not make you the absolute owner. Of course, in the records, ikaw ang legal owner. Pero your certificate of title is just an evidence of ownership. So if you don't have the ownership, if you did not acquire the property through any of the modes of acquiring ownership under Article 712 of the Civil Code, then that certificate of title will not protect you. Kaya we're talking about this common step, which is by sale, kasi nga one of the modes of acquiring ownership under Article 712 of the Civil Code is by tradition as a result of contracts of sale, assignment, etc. So tradition means delivery. Diba? Na-explain ko na yan in my previous video. So kung nakabili ka ng property which is already registered under the torrent system, which is of course the system of land registration, then these are the steps to get yourself a title to that property. Kasi syempre gusto mo magkaroon ka ng titulo over the property. Ayaw mo naman na nakabili ka ng property pero ang papeles mo is yung pa rin sa dating owner. Diba? So who would believe you are the owner of the property if on paper it was still the previous owner? Kaya sasabi ko, a certificate of title is the best evidence of ownership, and people will demand to see your certificate of title if you really are the owner. Okay, so the first step is to execute a deed of absolute sale or any proper deed of conveyance. And this is because as we have stated under Article 712, one of the modes of acquiring ownership is by tradition as a result of a contract of sale or simply a contract of sale. So a deed of absolute sale must be in writing. And not only in writing, it must also be in a public instrument. Now, don't get me started with the difference between validity as a reason for executing the contract in writing and the reason and convenience as another reason for executing a contract in a public instrument. But Article 1358 number 1 of the Civil Code is a requirement that contracts which have for their object the creation, transmission, modification, or extinguishment of real rights over immovable property must be or must appear in a public document. So Article 1358 number 1 of the Civil Code has been interpreted by the Supreme Court as merely for convenience of the parties. So gusto ko lang linawin na a contract of sale of real property is valid in whatever form. So valid siya kahit verbal. So kung kayo ay nakabili ng lupa at it's not in writing, ibig sabihin verbal lang, don't worry, that contract is still valid for as long as all the elements are present. Namely, the consent of the parties. Dapat nagkaroon talaga kayo ng kasunduan to buy and sell the property. Also, there must be a determinate thing involved. Ibig sabihin, the thing must be particularly described, and also there must be a consideration. Ibig sabihin, dapat may napag-usapang presyo at napag-usapan na kung paano siya babayaran. So basically, those are the elements. And if the elements are present, even if the contract is verbal, it is valid between the parties. However, Article 1358 gives or creates this obligation, this legal obligation, on the part of either or both parties to execute the contract in a public instrument. The reason is obvious. This is for purposes of transferring title to the property. So, kahit na verbal yan, valid yan, pero you need to have it reduced into writing and particularly in a public instrument kasi kakailanganin nyo yan for purposes of transferring title. All right? So there, that's your basis, Article 1358(1), why a deed of absolute sale is or should be in a public instrument. Now, take note na karapatan ito ng both parties or either of the parties in a contract or in a deed of absolute sale to have the sale in a public instrument. So kung halimbawa ako si seller, tapos nagkaroon kami ng kasunduan to buy and sell the property, tapos ngayon sinabihan ko si buyer na, oh, let's execute a public instrument, a deed of absolute sale. A public instrument means that it is notarized, di ba? So pag tumanggi siya, sabi niya, ayoko na. Besides, andito na sa akin ang lupa, binayaran na rin kita. So what's the point? Bakit pa tayo mag-execute ng public instrument? Ang sagot mo sa kanya, Article 1358 number 1, nasa batas kasi na that contract, our contract should be in a public instrument. So this is an obligation created by law na pwede kong i-demand sa kanya. So ganun din, lalo na usually it's the buyer really who is interested to have the sale reduced into writing kasi siya yung magpapalipat ng titulo. Okay? Now, present the deed of absolute sale to the BIR for purposes of paying the taxes, particularly capital gains tax. At meron pang documentary stamp tax dyan. Pero ang pinaka-importante dyan, yung capital gains tax, yun ang medyo malaki. Yung documentary stamp tax siguro as a very, very low percentage or little percentage na compared dun sa capital gains tax. Okay, now by the way, it should be a deed of absolute sale, whether it's bilateral or unilateral, ha? Okay. Ano ibig sabihin nun? Pag unilateral, yung isa lang ang nakapirma doon, no? So, first person lagi nakasaad doon. Like, I, Juan de la Cruz, for in consideration of 1 million pesos, hereby sell to Pedro Marquez that real property covered or embraced by TCT number 1234 and described as follows. Kanya, tapos pirma na siya. That's unilateral. Pero a bilateral contract is a contract whereby both parties sign in the instrument. Tapos nakalagay doon yung specific rights and obligations nila, ano pa mga ibang conditions, etc. So, whether it's unilateral or bilateral, the contract or the instrument should be a deed of absolute sale. Hindi pwede ang contract to sell or a deed of conditional sale because in a contract to sell or deed of conditional sale, wala pang transfer of ownership dun until the compliance or the fulfillment of the condition, which is usually the full payment of the purchase price. So kung ipapakita mo sa Register of Deeds or the PIR, for example, is a contract to sell, you would still have to submit proof that you have actually paid. And in some instances, it has to be replaced by the proper deed of conveyance. Like, for example, a contract to sell. A contract to sell will never be accepted kasi nga, as stated in Ursal versus Court of Appeals, sabi ng Supreme Court, if the parties executed a contract to sell, upon full payment of the purchase price, it does not automatically result in the transfer of ownership. The ownership or the seller will have to execute a deed of absolute sale to transfer ownership to the buyer. So see, following Ursal versus Court of Appeals, the BIR and other offices and even third persons will not accept or recognize as a contract to sell as a proper deed of conveyance kahit na meron ka pa proof ng full payment. Halimbawa, nagpakita ka ng resibo, nagpakita ka pa ng halimbawa text message, sabi ng seller mo, okay, fully paid ka na, wala na tayong relasyon ha, tapos na tayo. No, that will not be admissible, so to speak. Okay. So you present the deed of absolute sale, not a contract to sell, not a deed of conditional sale to the BIR and pay the appropriate taxes. Pagkatapos, hintayin mo ang CAR. What's the CAR? The Certificate Authorizing Registration. Yan yung ini-issue ng BIR as proof na nakapagbayad ka ng capital gains tax. So after that, you go to the city treasurer or the municipal treasurer to pay for the transfer taxes. Now, pwede itong gawin mo at the time na magpaparehistro ka na or pwede rin i-advance mo na. At any rate, wala naman kasi itong penalty. So pwede mo nang bayaran ngayon, pwede mo nang bayaran later. Pero kailangan mo magbayad nito kasi kakailanganin ito later sa Register of Deeds. Okay, now you go to the Register of Deeds. So what do you bring to the Register of Deeds? Obviously, you have to present and surrender the owner's certificate to the Register of Deeds, plus the proof of payment of the required taxes, both the capital gains tax, the documentary stamp tax, and the transfer taxes. And then, okay, before that, syempre, yung deed of conveyance mo, yung deed of absolute sale. So, ilang dokumento yon? Una muna, deed of absolute sale, proof of payment of your taxes, and of course, the owner's duplicate. Ano to owner's duplicate? Ito yung kopya or yung titulo na na-issue ng Register of Deeds sa seller mo or doon sa registered owner. Ngayon kasi kulay blue na siya pero dati kulay pula pa siya, no? So basta yun, nakakita na siguro kayo ng titulo, no? Pero kapag kulay blue pala, it could be a certified true copy. So not the certified true copy. Dapat the original owner's duplicate certificate. Okay, so yun, ipipresent nyo yun. Now, ang reason kung bakit kailangan i-present yun is that ika-cancel kasi yun. So remember, in my previous video, I said that once the title or once the property is registered, the original certificate of title is reproduced in two copies. One is the original certificate of title and the other is the owner's duplicate of the original certificate of title. Yung original, yun yung nasa Register of Deeds. Yung owner's duplicate, yun yung ini-issue dun sa registered owner. All right. So you wait now for the new certificate of title in the name of the buyer. And then present after getting the title or the certificate of title, you present the deed of absolute sale and the new transfer certificate of title to the city assessor's office for tax declaration. Now, baka iba-iba yan. May mga ibang assessor's office siguro that will require you to also show your proof of payment of transfer taxes. Basta dapat lagi kang merong extra copy ng mga sinasabit mo sa mga opisina like doon sa BIR, sa City Treasurer's Office at saka sa Register of Deeds, no? Because baka kailanganin din siya ng ibang mga opisina later. And besides to, pagka nakakuha ka ng bagong titulo, mag-a-apply ka pa siguro ng mga utilities, for maybe a building permit, kasi magko-construct, etc. So kakailanganin mo rin yung mga papeles na earlier pinagsasubmit mo sa mga opisina. So kaya kailangan meron kang extra copies. Okay. Now, let's discuss the requirements and steps naman for registration of an inherited land. Ito naman yung pangalawa sa pinaka-popular or pinaka-common na paraan ng paglilipat ng mga properties, no? So first I said was through sale sa bentahan, ito naman ay through succession or through inheritance. So first is ibig sabihin ng inheritance or succession, may namatay. Namatay yung may-ari ng lupa. Now, the first step is of course to settle the estate. Now, settlement can be done either judicially or extrajudicially. So judicial settlement of estate is required if the decedent left a will, or okay, if extrajudicial settlement cannot be had because the decedent left debts. No, so kaya hindi pwede extrajudicial settlement. So anyway, dadaan to sa korte itong judicial settlement. Now, if the proceedings end or after the proceedings end in a judicial settlement, then next is you present the final decision. I mean, you need to wait for the final decision in that settlement proceeding. Now, the other step or the other type of settlement is extrajudicial settlement. And that's the name suggests, extrajudicial. The settlement is done out of court. So the parties, mean to say the heirs, will adjudicate unto themselves the properties of the decedent by executing an instrument called an extrajudicial settlement, and then they will have to either agree to be co-owners of the property, or they could adjudicate the property to just one, two, or more of them kung marami sila. Now, nasa usapan na nila yan kung paano yung mga hindi nga makakakuha ng portion of the property kasi halimbawa hindi nila desisyon na hatiin ang property. So instead, they will just adjudicate or ipapangalan lang nila sa isa, dalawa, or tatlo sa kanila. Then, depende sa usapan, pwede nila pag-usapan na bayaran na lang yung iba. Bayaran na lang yung iba, ito na yung share nyo sa lupa. Pero dahil nga sayang kung hatiin natin to physically, so let's just keep it intact but adjudicate it to one, two, or more of us. Pero yung iba na hindi nakapangalan, then they will just get their share. And also, it is possible that the co-ownership will be maintained even if the property is registered in just the name of one, two, or more of them. So in that case, a trust is created. Okay, so the registered owners will be considered as trustee of the property for the benefit of the other co-owners. Okay, so sabi natin extrajudicial settlement na. So meron na sila papel. So this extrajudicial settlement is resorted to if the decedent left no will at wala rin siya mga utang. And also, the heirs are all of age, or the minors, if any, are represented by their judicial or legal representatives. Na may proseso ang extrajudicial settlement, ha. Una-una kailangan yan iparehistro. Okay, also, the extrajudicial settlement must be in a public instrument. So, notaryado yan. Okay, so whether it was done judicially or extrajudicially, let's talk about the next step. So the next step, as I said earlier, is to present the final decision, or kung extrajudicial settlement sila, present the extrajudicial settlement or the EJS to the BIR and pay the appropriate taxes. So same as the earlier procedure for sales. Now, next is to pay the transfer taxes to the city treasurer or municipal treasurer, as the case may be. And also, next is to register the final decision or the EJS with the Register of Deeds. Tulad na procedure din kanina. And then present and surrender the owner's duplicate certificate to the Register of Deeds. Again, for the same reason, kailangan makancel yan kasi nga hindi pwedeng more than 2 titles are issued to the same property. So, ipipresent, iso-surrender yung owner's duplicate para nga makapag-issue ng bago. So kung the property was adjudicated to just a specific person, then the new title will be in the name of this person, no? So whether by judicial settlement or extrajudicial settlement siya napili, siya na ngayon ang nakapangalan sa bagong titulo. So yung old title in the name of the decedent or the person who died, maka-cancel yun. Okay, so next, aside from presenting the final decision or the EJS with the Register of Deeds, as well as the owner's duplicate of the certificate of title, the applicant or the registrant must also present and submit proof of payment of the required taxes. Also, and then finally, after submitting all these, wait for the new certificate of title in the name of the heirs. And then present the final decision or the EJS and the new TCT to the City Assessor's Office for the issuance of a tax declaration. Again, like what I said earlier, always keep extra copies of all your documents because you might need them later when you apply for stuff. And then also when you make a construction on your building or on your property, again, requiring proof of your ownership, proof of your payment of taxes, etc. So, mas maganda may extra copy ka. Alright. So, dito na tayo ngayon sa topic on due diligence in buying lands. So, ano ba ibig sabihin ng due diligence? So, basically, when you say diligence, it means due care, yung pag-iingat. So, under the civil code, ang basic, pinakamababang klase ng pag-iingat ay ang simple diligence o tatawag na diligence of a good father of a family. Ayan. So I know it's kind of sexist because bakit father lang? Di ba pwedeng mother? In fact, mas maingat pa nga, ano, mas careful pa nga or cautious pa nga ang nanay, di ba, kaysa sa tatay. Although, of course, that is a case-to-case basis. I'm not saying it that it's the absolute truth, but generally, and I'm sure many of you will agree, that because women, especially the mothers, are charged with most of the critical thinking in the family or in the household, kaya sila madalas din ang mas careful. Now, when you say critical thinking, I think it's more about balancing all priorities. No? Sa dami na iniisip mo, hindi ka pa ba magiging best in critical thinking doon? Iniisip mo yung budget, iniisip mo yung assignment ng mga anak mo, iniisip mo yung paglilinis ng bahay, at saka iniisip mo rin kung nasaan ang asawa mo, baka nagpapa-change oil yan. I mean, nagpa-change oil na siya kahapon na, pa-change oil siya ulit. Joke lang. Anyway, now, I want to be politically correct. Baka mamaya sabihin nyo, lahat ng description ko, they're so stereotypical. I mean to say, I'm perpetuating the stereotype. I'm not, and I don't intend, to perpetuate the stereotype. Pero the fact is, as it is commonly known, and as we all can agree to recognize, that most women or mothers are relegated to this kind of tasks at home and responsibilities. So kaya sila nagiging more cautious. No? But okay, anyway, regardless. So let's just use parent instead, no? Just so we can all be politically correct. So anyway, the minimum diligence required under the civil code is the diligence of a good parent of a family. But you see, when buying lands, it's more than diligence of a good father of a family or good parent of a family. Although I'm not saying it's extraordinary diligence, kasi pag sinabi mong extraordinary diligence, then that usually is reserved for common carriers, banks, etc. na sobrang taas ng kanilang degree of care talaga when performing their responsibilities or their obligations. So dito sa pagbibili ng lupa, the Supreme Court has described it almost invariably. Ibig sabihin, consistent as Supreme Court. So una-una, may direct and close connection ang due diligence sa konsepto ng innocent purchaser for value under, I think, Section 32 of PD 1529. A purchaser for or an innocent purchaser for value kasi is protected under the law kahit na the source of the title was a forgery or was an irregularity. For example, the original owner acquired the property through fraud na parehistro niya sa pangalan niya. Na ngayon, nabenta niya sa ibang tao, itong ibang tao na to, wala siyang kaalam-alam about the irregularities committed by his or her transferor. So that second buyer or this buyer is deemed or can be deemed an innocent purchaser for value. When I say can, kasi nga, kailangan mo rin kasi i-prove yun. So anyway, an innocent purchaser for value, as defined, is one who buys the property of another without notice that some other person has a right to or interest in it, and who pays a full and fair price at the time of the purchase or before receiving any notice of another person's claim. So as a general rule, every person dealing with registered land may safely rely on the correctness of the certificate of title. Ibig sabihin, may karapatan siya na tingnan lang yung titulo. Okay? And the law, sabi pa ng definition, will not in any way oblige him or her to go behind the certificate. Of course, this is only figurative. Hindi ibig sabihin na pupunta siya sa likod ng titulo. Ang ibig sabihin is kapag wala ka nang nakita on the title, okay na yun. You don't need to go beyond, no, or behind the certificate of title when there is really nothing, no, to be suspicious about. So the law does not oblige him or her to go behind the certificate to determine the condition of the property. Simply put, when a certificate of title is clean and free from any encumbrance, a potential buyer has every right to rely on the correctness of the certificate in making his or her purchase of real property. In such cases, the buyer is often referred to as an innocent purchaser for value and in good faith. Okay. Conversely, ibig sabihin, on the opposite or on the contrary, the buyer will not be considered an innocent purchaser in good faith or for value if he or she had actual knowledge of a defect or the lack of title of the vendor over the property or anything on the title that would reasonably arouse suspicion. So kung meron siyang kahit konting knowledge or kaalaman tungkol sa mga depekto sa titulo ng kanyang seller, eh hindi siya innocent purchaser for value, no? Kaya sabi dito, um, if there is a lack of title of the vendor over the property or anything on the title that would reasonably arouse suspicion, and he or she failed to inquire or to take the necessary steps to ensure that there was no cloud on the title, right, or ownership of the property subject of the sale, then the buyer will be considered as a buyer in bad faith. Okay. Now, halimbawa, may alam ka, ano ba ikaw yung buyer? So alam mo na may problema itong property na to. Alam mo na may claimant halimbawa. Although ang titulo nandun sa pangalan ng seller mo. Pero may alam ka na may third party claimant. So you proceeded to buy the property. You are not an innocent purchaser for value. You're a buyer in bad faith. So what now? Well, the law says the innocent or the buyer in bad faith will not be protected by law in case the third party claimant succeeds, in recovering the property. So kasi alam naman niya na may problema, so hindi mo na masisisi. Wala kang ibang sisisihin kundi sarili mo because you took the risk. Ayan. So a buyer in bad faith takes the risk of loss. Okay? May risk na baka mawala yung property sa kanya and he has no one to blame but himself. Okay. Further, where innocent third persons relying on the correctness of the certificate of title thus issued acquire rights over the property, the court cannot disregard such rights and order the total cancellation of the certificate. The effect of such an outright cancellation would be to impair the public confidence in the certificate of title, for everyone dealing with property registered under the torrent system would have to inquire in every instance whether the title has been regularly or irregularly issued, and this is contrary to the evident purpose of the law. So kung innocent purchaser for value na yung present owner na yan, hindi yan dapat, yung titulo niya dapat hindi basta-basta kinakansela. Okay. Now, the mirror doctrine is basically yung sinabi na kanina na you can safely rely on the title if on its face it doesn't arouse any suspicion as to a defect in the title of your seller. So, but literally, I hope tama ito aking literal interpretation kasi nga since law school, iba-iba interpretation ng mirror doctrine. Pero as the name suggests, you look at yourself at the mirror and then you say, ang ganda-ganda ko. Or you look at the mirror and then you find flaws in your face. And then you say, I have to deal with this. I have to go to the dermatologist. Or maybe I should just change my soap, from Mr. Clean to Perla or something. I don't know if you're watching this and you've been you've lived through the 90s. I'm sure you heard back then na ang Perla daw nakakatanggal ng pimples. So kaya yun. Anyway, ang harsh naman ako Mr. Clean ang sabon mo sa mukha tapos upgrade to Perla. But anyway, yun na nga, to some effective nga rin yung Perla. Pero yung white, hawag yung blue. Anyway, so please tell me in the comment section below kung meron pang Perla na binibenta ngayon sa supermarket. Kasi ngayon dahil nga nag-washing machine na tayo, so hindi na tayo nag-hand wash, so lagi kaming tawag yan liquid detergent. So yun. Anyway, kung meron mang perla, well, siguro yun, maybe for all time's sake, siguro bibili siguro ako. Because syempre, meron pa rin mga damit tayo na dapat hina-hand wash like mga puti at saka yung mga delicate. You don't, wash them in the laundromat. Anyway, so going back. Sabi ko sasabi. So sa mirror doctrine, titingnan mo sarili mo sa salamin, and then if there's anything suspicious, you deal with it, di ba? Well, depende. Meron naman iba, you just embrace your imperfections. So that's it. Pero, what I'm saying is that it's all about knowledge. So if you look at the mirror and then you see something, then you acquire that knowledge of a defect in what you see. So similarly, ganun din sa titulo, consider the title as a mirror. If it reflects something that should raise your suspicion, then you should do something about it. Pero if it doesn't reflect anything back at you, then it's okay. You can rely on the cleanliness of the certificate of title. Kumbaga, when you look at the mirror at wala ka naman nakikitang flaws sa nakikita mo sa salamin, then you can safely rely and say, ang ganda-ganda ko. Okay. So next is every person. Okay, anyway, as I was saying, ito na nga yung sasabi ng Locsin versus Hiso, and this is the meaning of the mirror doctrine. Every person dealing with registered land may safely rely on the correctness of the certificate of title issued therefore, and is no way obliged to go beyond the certificate to determine the condition of the property. Oh, by the way, I hope you're still with me. I know most of you might just be watching my videos in the early minutes. I know it's kind of long, no? So mga videos ko matagal. Pero I really, really appreciate it if you're watching and finishing the entire video. Ibig sabihin, you're really searching or trying to learn more, from this video. Okay, so anyway, in the following instances, it is not safe to just rely on the title because mere reliance on the title here is not applicable or is not sufficient. So the first situation is when the party, I'm going to say the buyer, has actual knowledge of facts and circumstances that would impel a reasonably cautious man to make such inquiry. Sorry ako medyo sexist. I mean, sorry. Meron kasi tayong gender sensitivity language na ngayon, and in fact, the Supreme Court has advised all of us to not use a specific gender. So for example, yung he, wag na daw he, so dapat plural there, etc. But since I'm quoting this from a decision, so let me just quote it as it is. So kaya man ang ginamit siya sa halip na person. So anyway, again, the first situation is when the party has actual knowledge of facts and circumstances that would impel a reasonably cautious man to make such inquiry. Or when the purchaser has knowledge of a defect or the lack of title in his vendor or of sufficient facts to induce a reasonably prudent man to inquire into the status of the title of the property in litigation, or the presence of anything which excites or arouses a suspicion. Okay, so for the first situation, imagine several things that could make you cautious, no? Make you want to ask for more. Make you want to ask, no, bakit meron yan? Or bakit ganyan? Good example is meron ibang occupant. Bumili ka ng property kay Juan, pero nung inocular inspection mo yung property, bakit nandun si Pedro? Nung tinanong mo, sino ka? Sabihin niya, ikaw, sino ka? Ako si Pedro. Dito ako nakatira. At akin itong lupa ito. So syempre hindi ka na naka-imik, no? Pero, bakit ganon? May nag-aangkin ng lupa, nabili ko to kay Juan. So pagka ganon, tanungin mo bakit? No? So bakit ka ba nandyan? Paano po kayo naging may-ari? Ganyan, ganyan. Kilala niyo po ba si Juan? So yeah, so the more information you get, the better, so that you can make an intelligent decision whether to buy it or not. Now, if you buy it, as I said, with that knowledge, you're buying it in bad faith. So, wag kang magrereklamo kung halimbawa matalo ka sa kaso na ifinailaban sa iyo, or kung ikaw ang nag-file natalo ka kasi nga mas malakas yung karapatan niya. So, wala ka karapatan na magreklamo kasi nga you are in bad faith. Okay, now for the second situation, let's say the person selling the property to you is an agent, or let's say a co-heir, yung mga ganyan. So meron pa ibang mga tao, no, na who is recorded as an owner, particularly the certificate of title. So pagka ganyan, you have to ask, bakit? Sino ka? Ano ang extent ng authority mo to sell these properties? You have to go to the principal of that agent or you have to check with the other heirs kung ano ang authority nitong ano mo, itong katransaction mo, itong kausap mo. Okay, next, the presence of anything which excites or arouses suspicion. Well, halimbawa, nakita mo when I check the property, bakit nakausli yung or nakapasok or naka-encroach na yung, let's say, kusina ng kapitbahay nung seller mo dun sa property ni seller na binibili mo nga ngayon. So yung mga ganyan. So like questions about or issues, possible issues, lalo na po mga obvious na issues on boundaries, isa yan sa mga dapat nag-excite or nag-arouse ng suspicion mo. So, ibig sabihin yung area, dapat chine-check mo na agad. So, kaya later on, kung halimbawa aware ka na mas maliit pala doon sa binili mong property, hindi ka pwede magreklamo na ang binili ko 100 square meters or 1,000 square meters, pero alam mo naman talaga na 90 square meters lang or 900 square meters lang yung property. Diba? Alright. So this, sabi na Supreme Court, should prompt the vendee to look beyond the certificate and investigate the title of the vendor appearing on the face of said certificate. So one who falls or who fails or who falls within the exception can neither be denominated as an innocent purchaser for value nor a purchaser in good faith and hence does not merit the protection of the law. So ano ba ang dapat gawin? So pagka meron kang binibiling property, whether your whether the title is clean or not, I think these steps should apply or should be standard, no, for every buyer of real property, just so you can be considered as an innocent purchaser for value. Okay, so first is verify the origin, history, authenticity, and validity of the title with the Office of the Register of Deeds and the Land Registration Authority. So again, verify the origin, history, authenticity, and validity of the title. So dahil kasama dyan ang origin and history, dapat chine-check mo rin yung mga previous titles na na-issue over the said property. At dapat nagtutugma yung mga predecessors, no, at saka yung mga transferees. So, halimbawa, this present title is a replacement or kumbaga this cancels. Usually nakalagay dyan, itong title na ito, kinansela yung ganong title, tapos hanapin mo naman yung na-cancel kasi makikita mo rin kung ano ang kinansela niya. So, tinitrace mo lahat yan. Just so kung halimbawa merong later on question na bakit ka may titulo siya may titulo, so at least you can show na, I did a tracing, so I trace my title to the very original, diba? Meanwhile, yun sa'yo, o nasaan, ano ang source niyan. So, yun. So, kailangan mo tinitrace ang mga titulo mo. Okay, ang mga titulo ng property pala. Next, engage the services of a competent and reliable geodetic engineer to verify the boundary, meets, and bounds of the lot subject of said title based on the technical description in the said title and the approved survey plan in the Land Management Bureau. Okay, so kailangan mong ma-check yung boundaries mo just so walang issue ng encroachment. Okay? And of course, conduct an ocular inspection of the lot. No? It's never advisable to buy lands by simply looking at pictures, by simply watching a video of the property. You have to be there personally. You have to see it with your own eyes, na physical eyes, na kung ano itsura ng property, kung sino nakatira doon, kung meron man. Ayan. In fact, mas maganda nga yung mag-ocular inspection ka muna before, checking before doing the tracing of the property or before. Siyempre, pag nagpa-survey ka na, makikita yan. What if nagpa-survey ka na, hindi mo pa rin in-ocular inspection? Yung engineer lang nagpunta. Hindi yun enough. Kailangan mag-ocular inspection ka talaga. Ikaw mismo nakikita mo yung property. Alright. Now, also, makichismis ka, makimarites ka, no? So, you inquire from the owners and possessors of adjoining lots, meaning to say, mga neighbors, with respect to the true and legal ownership of the lot in question. So, sasabihin nila sa inyo kung sino ang nalalaman sa kanila pagkakaalam, kung sino ang owner at saka previous owners of the property. And that way, again, pag nag-tracing ka, ma-check mo kung tugma ba yung nasa papel, may sabihin nasa mga titulo, both present and past, and also yung mga kwento ng mga kapitbahay. Next, ito usually nakikita ko na rin to, no? Pero siyempre iba-iba diskarte yan. Pero may mga nakita na ako mga signs na ganito. Like putting up signs that the said lot is being purchased, land or leased or encumbered. Or in fact, when you have already purchased the property, lagyan mo pa rin ng ganon. But we're talking about due diligence prior to the sale, di ba? So nakalagay dyan is being purchased. To say is planned to be purchased. The reason for this is to excite curiosity for people and especially the neighbors, and also to attract possible claimants to the property. So kapag naglagay ka ng sign na ganyan na this is being purchased by Juan de la Cruz, so may mga papakita dyan. Sabihin, ikaw ba si Juan de la Cruz? Ako po kasi ang totoong asawa. Hindi. Hindi. Okay, iba pala. Yan. Kwento pala na tao dyan. Kabit pala. Kabit system pala ang naisip. Anyway, next is, of course, this would include such other measures to make the general public aware that said lot will be subject to alienation, lease, or encumbrance by the parties. Okay, so that's still from the case of Locsin versus Hizon. All right, so next, let's talk about recording of encumbrances. So encumbrances are also called the voluntary dealings. No? So the property, once registered under the torrent system, can be the subject of a sale, the subject of a lease, subject of a mortgage. Now, also the property can be a security for a pending case in court, etc. So all these are transactions that do not result in the transfer of ownership. So it will not result in the cancellation of the old title. So kung hindi naman pala i-cancel ang old title at walang i-issue niyan na new title, so anong gagawin doon sa mga encumbrances na yon? So these encumbrances will simply be recorded or annotated. So ano ba ang legal basis dyan? So Section 51 of PD 1529 states, an owner of registered land may convey, mortgage, lease, charge, or otherwise deal with the same in accordance with existing laws. He may use such forms of deeds, mortgages, leases, or other voluntary instruments as are sufficient in law. But no deed, mortgage, lease, or other voluntary instrument except a will purporting to convey or affect registered land shall take effect as a conveyance or bind the land, but shall operate only as a contract between the parties and as evidence of authority to the Register of Deeds to make registration. I know. Confusing. Gano'n talaga, no? If it were not confusing, then it would not be law. And a joke lang. You know what? Hopefully, our legislators will make our laws simpler para mas maintindihan ng kahit hindi mga abogado, no? So, tulad nito, ipa-paraphrase natin, ang ibig lang sabihin nito is deeds, mortgages, leases, and other voluntary instruments to be binding on other persons, means to bind the land and to bind other persons, must be recorded in the Registry of Deeds. But if they are not recorded, then they are nevertheless valid and binding between the parties. Okay, so again, ulitin lang natin. Ano ba purpose of registration? Notice to the whole world. But as to the parties concerned, their contract, whether recorded or not, is binding between them. Okay. Now, the act of registration shall be the operative act to convey or affect the land insofar as third persons are concerned. See? And in all cases under this decree, the registration shall be made in the office of the Register of Deeds for the province or city where the land lies or where the land is located. So again, territorial jurisdiction. So it shall be the Register of Deeds of the place where the property is located. All right, so here are the voluntary dealings or transactions that are stated in the law, but these are not exclusive, mind you. Baka may mga maisip pa ang mga tao na mga ibang transaction, they can also be recorded. Pero ito yung pinaka-common. So, example, sale or purchase, mortgage, lease, power of attorney, trust, etc. So, on the left column, andyan yung mga dokumento or yung mga transaksyon. Dito naman sa pangalawang, yung nasa gitna na column, yan yung mga documents na mga dapat ipresenta doon sa Register of Deeds. Again, the Register of Deeds who has uh, territorial jurisdiction over the place where the property is located. So doon ito ipipresenta. Now on the third column to the right, my right, are or is the action of the Register of Deeds upon receiving these documents, and of course may mga payment of fees, etc. And also after sufficient application or request, no? So ito yung gagawin. So kaya nabanggit ko na kayo na in case of sale or purchase, present a deed of conveyance and the owner's duplicate, and then the Register of Deeds will cancel the old title or certificate of title and issue a new one. So for a mortgage, so surrender the deed of mortgage and the owner's duplicate of the certificate of title, and then the RD will annotate on the original as well as the owner's duplicate the existence or the details of the mortgage. All right. So I will leave the rest to your reading pleasure, so to speak. Hopefully, you're watching this video on a large screen. Kasi napansin ko yung previous video ko pala medyo maliit pag sa telepono. So, yun. Anyway, kung medyo naliliitan kayo sa text, I think ang mga phones ngayon pwede mo na i-pinch and zoom, di ba? So, yeah, pwede mo na i-pinch and zoom kahit hindi mo na ako nakikita. No? Pero sayang naman, no? Panoorin mo rin ako. Aside from, of course, the text. Pero yeah, okay, it's your choice, whatever. Kung paano kayo nag-enjoy manood. Assuming nag-enjoy nga kayo. Yeah, I hope so. All right? So, kung you're still with me, congratulations, no? Kasi walang magpapahinga. All right, so let's go to the next or to the other encumbrances. Ito naman ngayon, starting with attachment down. These are legal encumbrances, or sometimes you may call them judicial encumbrances. So, for example, attachment. So, an attachment is a provisional remedy under the rules of court whereby the property is being held as security for the judgment in the case. So, kaya may court order yan. No? So, may court order placing the property under attachment. Now, the RD, once receiving the court order, will annotate the attachment or the writ of attachment as well as the details of the case on the original of the certificate of title. Now, notice immediately ang pagkakaiba nitong andito sa table na to at sa kayo previous table. Doon sa dito sa itong table na ito nakikita nyo, dito sa action by the RD, may annotation sa original certificate of title na nasa possession na RD at saka sa owner's duplicate. Pero dito sa mga involuntary dealings, as we call them because they are forced by the court or by law, wala nang annotation sa owner's duplicate because hindi naman required na isurrender ang owner's duplicate. So kaya, okay, the reason is obvious. These are all compulsory processes. So cases or claims are filed against the registered owner. Parang malabo na yung registered owner, i-volunteer niya yung kanyang titulo. Sabi niya, pues, sabihin niya ganito, no? Bigla sa nila remember the song of Shakira. Sabi niya, okay, anyway. Maybe it's just me being sleepy. Anyway, pero bawal matulog ka. Wala magpapahinga. Now, don't ask me kung ano oras ko nire-record ito, but I'm telling you, it's way past my bedtime. Okay, anyway, so, sabihin ni registered owner, bakit kayo volunteer yung titulo ko para para mantsahan nyo? No, ng mga ng mga attachments ko, ng mga encumbrances. No way. Ganyan yan. So anyway, the court will simply issue an order and direct the Register of Deeds na i-annotate ito. Okay, so that's for attachment. Now, adverse claim, on the other hand, does not require a court order. Instead, it requires an affidavit. So the affidavit is executed by the claimant or the person who has an adverse claim on the property. So the adverse claim may take the form of, let's say, or as an example, an adverse claim may be, say, a buyer in a contract to sell. So lalagyan na adverse claim yan. Sabihin niya na meron akong right in expectancy that this property will be purchased by me, or that this property will be owned by me eventually after I paying the purchase price. So who else? Whether an heir who was not registered or who was not given his or her share. So hindi rin siya na-rehistro or na-record doon as one of the co-owners. So mag-file siya ng adverse claim. So yan. So i-annotate lang yan ng Register of Deeds. Now, yeah, about adverse claim, medyo iba-ibang rule ng mga Register of Deeds dyan. Some registers of deeds will accept the adverse claim and will just record them ministerially to say they consider it as their ministerial function. Pero meron ding ibang mga registers of deeds na mabusisi. So they will ask about the substance of the adverse claim. So may mga interview portion pa yan. Pero you see, under the law, dapat wala nang ganon. Pero okay din na cautious lang din ang Register of Deeds to avoid the adverse claim to be used, to avoid tama ba? How should the sentence be? To avoid the adverse claim, para maiwasan na magamit ang adverse claim as a way of harassing the registered owner. So kung halimbawa hindi iniimbestigahan or hindi tinatanong ng Register of Deeds yung adverse claim na yan or yung substance yan, baka lahat na lang mag-file na adverse claim. So halimbawa, may isang mag-file na adverse claim, tapos pag tinanong mo, pag hindi mo tinanong, tapos inirehistro mo lang, ayun pala ang reason lang niya is gusto ko lang siya i-reserve kasi para pag pumasa ako sa bar exam after 15 years, mabibili ko yung property na yan. O diba, yung pangarap niya, ginawa niya adverse claim on the property. Okay, anyway, notice of lis pendens is a written notice of the action, or it requires the submission of a written notice of the action, the court, the date of institution of the action, description of the affected landowners, and the description of the affected landowner. So this notice of lis pendens can actually be filed by the lawyer. So no need for a court action dyan. Okay, so how do you discharge or release voluntary and involuntary dealings? So doon sa mga nakapagsanlanan ng mga bahay nila, so alam nyo na mangyari, pagbayad ka na, you will now be issued by the bank a discharge or a cancellation of mortgage. So it's an instrument, it's a piece of paper that you also register with the Register of Deeds para makansela at ma-discharge yung mga annotations. So yan. So Section 62 of PD 1529 states that a mortgage or lease on registered land may be discharged or canceled by means of an instrument executed by the mortgagee or lessee. Also, a power of attorney may be canceled by an instrument revoking the power of attorney. Attachments and liens may be discharged by a court order or decision. Ay, bakit nawala? Kulang to. An adverse claim may be discharged by a court order. Okay, now, you might be asking, why is it that pag nag-file ka ng adverse claim, affidavit lang? Pero para matanggal yan, you have to file a case in court. Yun ang sabi ng Supreme Court eh. Ang remedy to remove an adverse claim is an action in court. Pero may exception dyan. The exception is if the adverse claimant files an affidavit withdrawing or canceling the adverse claim. Diba, unilateral cancellation. So, paano mangyayari ito? A good example would be this. So, kung ikaw yung registered owner, may nag-file na adverse claim, you reach out. You reach out to the adverse claimant at ayusin yung problema nyo. Pag naayos na ang problema nyo, isama nyo doon sa kasunduan ninyo na tanggalin dapat ng claimant yung adverse claim. So, halimbawa, kapitbahay mo yan or kasamahan mo, kabarangay kayo, or you live in the same city or municipality, then di ba sa barangay kayo niya magkaharap. So during the barangay conciliation hearing, pag-usapan niyo na yan tungkol sa adverse claim na yan para matanggal. So gawa siya ngayon ng affidavit. No, so an affidavit discharging another affidavit. Okay. So let's have additional topics. I'm going to just discuss three. Okay? Three topics. Bilis lang to. This is the cadastral system of registration, the system of registration for unregistered lands, and assurance fund. So I'll start with cadastral registration. Now, cadastral registration is the registration initiated by the state. Tapos ang ultimate result ng cadastral registration is number one, identifying lands which are already occupied by private persons and awarding these lands to the occupants. Now, so instead of these individuals filing their applications for registration either by free patent or by judicial confirmation of imperfect titles, ang estado na mismo ang nag-initiate. Okay, so ang complainant mo or ang applicant mo pala is the state, ang mga claimants at saka respondents are the actual occupants. So sila magpa-file ng answer, no? Sila magpa-file ng answer and then they will have to establish their right or their ownership of the lands. Unlike when the application is initiated by the applicant, by the private person, siya yung petitioner or yung applicant, then kailangan i-establish niya yung kanyang proof o kailangan niya i-establish yung kanyang ownership over the land. Tapos yung mga oppositors, kukontrahin lang siya. No? Anyway, so this cadastral registration is pursuant to the initiative on the part of the government that titles for all the land within a stated area are adjudicated or awarded. The government is the plaintiff and all the claimants are the defendants, hindi pala respondents, defendants. It is commenced by a cadastral survey preparatory to the filing of the petition. So, siyempre gagawa ng cadastral survey would be the Land Management Bureau. Now, when the lands have been surveyed or platted, the government shall institute original registration proceedings by filing the necessary petition in the RTC having territorial jurisdiction over the place where the property is located. So next, claimants, yung mga nakapangalan doon, and even those who are not named, pag alam mo na merong cadastral proceedings at apektado ka, ibig sabihin kasama yung property mo doon sa survey, sa cadastral survey, you have to file an answer stating the length of possession and the manner of acquisition. So ito yung sasabi ko, proof of ownership. Bakit ka nandyan at wala ka doon? Bakit ka nandyan? Paano ka napunta dyan? Anong karapatan mo dyan sa property na yan? So the court will have to decide all conflicting interests, including the opposition of the state. Na syempre, mag-file yun ng answer. So ang state naman may alam about the property. Sabihin niya, hindi naman ikaw nakatira doon. So all these conflicting interests shall be adjudicated by the court and decrees awarded in favor of the persons entitled to the lands and shall decree or whatever. Para mali yung grammar dito. Anyway, to the lands or to parts thereof, and such decrees shall be the basis for issuance of original certificates of title in favor of said persons. Okay? Gets na. That's cadastral survey. All right. Now let's talk about registration of unregistered lands. Pwede ba yun? Registration of unregistered lands? Di ba pagka they are registered, therefore they are called registered lands. Ang ibig sabihin ito, registration of unregistered lands. This is a system of recording transactions involving lands which have not yet been issued titles. So may batas tayo, Act 496, Act 3344, including section 113 of PD 1529, which mandate the Land Registration Authority to maintain a primary entry book and a registry book of deeds affecting unregistered lands. So registration under this law is purely voluntary. So yung mga transaction kanina, like mortgage, lease, power of attorney, those can be recorded in this primary entry book or registry book involving unregistered lands. So, paparehistro mo halimbawa yung mortgage over the property, uh, which is the subject of the contract of mortgage nga. Pero remember that it's purely voluntary, it's not mandatory. The parties must have agreed to register the transaction and the agreement expressly stated in the document sought to be registered. Now, the deeds affecting unregistered lands are valid between the parties, even if they are not registered. No? Again, this is only for convenience of the parties. Gusto lang nila ma-record so that, kasi if it is recorded, then there is a higher chance that this will not be repudiated. Pero pag hindi mo ni-record ang mga kontrata mo, lalo na yung mga verbal, mare-repudiate yan eh. Lalo na kung hindi na maganda ang relasyon nilang dalawa, no? Bigla na sila nag-away ganyan. So, yun. Baka ma-repudiate. So, mahihirapan ka ngayon mag-file ng kaso or the fact na kailangan mo pa mag-file ng kaso, it's not really good. Pero kapag nandito, pinarehistro mo na lesser chance na ma-repudiate, no? Or ma-deny ng kabilang partido at saka lesser chance na magkaroon ng kaso. Okay, anyway, so tax, sale, attachment, and levy, notice of dispendents, adverse claim, other instruments in the nature of involuntary dealings may also be recorded. See? Yan. Okay. Next up, let's talk about the assurance fund. So what is the assurance fund? So the assurance fund is like an insurance, no, for those who suffer damages by reason of the operation of the torrent system. The torrent system, is aimed or intended at putting order in the registration of lands, in the transactions dealing with registered lands. So it is really intended for protection of the registered owner, protection of the persons dealing with this property. But paano kung meron na biktima pala? So halimbawa, we celebrate the persons whose names are printed in that certificate of title. We celebrate the order by which transactions are recorded, affecting this land. Yung pala behind this all is someone who has been deprived of the property. Dahil sa mas may matalino sa kanya, or may nakakuha ng magaling na abogado na nakakaalam ng proseso, siya itong uneducated or someone who has no courage to avail of legal remedies, etc. Siya ngayon yung nawala ng property. In other words, yung totoo talagang kaso ng land grabbing, no? Halimbawa, na biktima siya ng land grabbing. So, anong pwede niyang gawin? So, again, na-discuss ko na in the first video, yung incontrovertibility of titles, indefeasibility of titles, etc. So, kaya hindi mo basta-basta maku-question ang title. But then, behind this all is someone weeping, sorrowful, because the very law that was intended to protect the person was the very same law which cost him his property. Diba? So ano gagawin niya? Thankfully, meron tinatawag na assurance fund. So it is a state fund for the compensation of a person injured by the unlawful or erroneous issuance of a certificate of title. Now, to be entitled to compensation, the following requisites must be met. Number 1, the claimant, who must be an owner, purchaser, or encumbrancer in good faith, suffered actual damage by the loss of land or interest therein. Number 2, that there was no negligence attributable to him or her. Okay, so hindi dahil sa kapabayaan niya, hindi dahil sa laches, hindi dahil sa prescription na nawala yung property niya. So, ibig sabihin, dapat nag-exercise siya ng due diligence, pero ganun pa rin talaga. Nawala pa rin yung property. Now, that the loss or damage suffered was not occasioned by a breach of trust, whether express, implied, or constructive, or by any mistake in the resurvey or subdivision of registered land, resulting in the expansion of area in the certificate of title. Ito hindi pwedeng maging dahilan. At kung ito ang naging dahilan kung bakit nga nawala yung property sa kanya because of, let's say, breach of an implied constructive or resulting trust or by mistake in the reserve, etc., the iba na remedy niya, hindi against the assurance fund. Or maybe as a result, wala na siyang remedy talaga. No? Okay, now the claimant is, by the provisions of the Land Registration Authority, barred or in any way precluded from bringing an action to recover the land or the interest therein, or from obtaining compensation direct from the person responsible for the damage. So, ibig sabihin, last resort ang assurance fund. Now, next, that the action to recover from the assurance fund has not prescribed. Kailan nagpe-prescribe ang action against the assurance fund? Mamaya ang sagot. Okay, next, that the loss or damage was due to any of the following causes. Number one, through the omission, mistake, or misfeasance of the clerk of court or the register of deeds, or any employees engaged in the performance of duties under the Land Registration Act and or other persons who committed fraud or other wrongful acts, or by the registration by any other person as owner of such land, or by the mistake, omission, or misdescription in a certificate or owner's duplicate or in any entry or memorandum in the register, and also by any cancellation. So ito yung mga grounds na pwede niyang gamitin. All other grounds, including yung kanina, ayan o, breach of trust, mistake in the resurvey, hindi yun pwede. So, ang allowable lang na ground for a claim against the assurance fund is etong apat. No? So, yung fault ng government officers, yung registration by another person, tapos may mistake, etc. in the certificate or others duplicate or the owner's duplicate, and also by cancellation of the title. So, itong mga grounds na to, pwede yan. That will give the aggrieved party grounds to file an action or claim against the assurance fund. So, sino ba dapat ang magiging defendants mo in the action against the assurance fund? So, sabi sa batas, the action shall be brought against the registrar and the national treasurer. Okay? The register of deeds as well as the national treasurer. Bakit ang national treasurer? Kasi ang national treasurer ang nag-administer ng assurance fund. Okay, by the way, if you're watching, where does the assurance fund get its money? Well, andyan yan sa mga transaction nyo with the Register of Deeds. Merong portion ng mga fees na binabayaran nyo na napupunta dyan sa assurance fund. Okay, next. If there are private persons involved in the above irregularities, such private persons should also be included as co-defendants. Now, lastly, the Solicitor General, in person or by representative, shall appear and defend all such suits to recover from the assurance fund. Okay, so isasama mo yan ang Solicitor General. Pwedeng hindi mo na talaga isama kasi parang tsaka naman yung abogado ng estado, ng gobyerno, ginawa mong defendant. And defendant is already the registrar and the national treasurer. Huwag mo na isama yung abogado niya. Ginagawa lang niya yung trabaho niya. So as lawyer ng state, papadalhan mo ng kopya. Ganun lang. No? Na dapat may notice of the pendency of the case. Katulad lang sa annulment at sa carnality of marriages. No? Kailangan meron kang sulat, ipapadala na nag-file ka nga ng kaso para nga makapag-enter of appearance yung Solicitor General. Pero usually naman, i-deputize nila ang piskal, yung naka-assign doon sa court na yun. Okay, so what's the prescriptive period? The prescriptive period is 6 years, ladies and gentlemen. So the 6-year period, according to the case of, okay, I hope I can pronounce this correctly, Stylianopoulos versus Register of Deeds. Sabi ng Supreme Court, the prescriptive period shall be reckoned from the moment the innocent purchaser for value registers his or her title. Ibig sabihin yung registration itong title, yung present title, na siyang dahilan kung bakit nawalan ng lupa or karapatan itong complainant or yung claimant, plus actual knowledge ng complainant of the original title. or the certificate of title, which is in the name of the innocent purchaser for value. So mas importante yung actual knowledge, no? So if the actual knowledge comes later, then yun ang uunahin. Now, we don't apply here yung sinasabi nating registration is notice to the whole world. No, kasi sabi ng Supreme Court kasi kailangan meron the actual knowledge. But it's good to read sana this case. So if you can read this case, do read this case. Kasi sabi naman ng kaya nasabi ng Supreme Court ito dahil sa the the claimants here were not in the Philippines at the time the property was registered. So wala kasing extraterritorial application ang notice, you know. Although sinasabi natin notice to the whole world, pero hindi naman siya notice talaga literally to the whole world. Pag nasa ibang bansa ka, hindi ka naaabot ng notice na yon. Kasi application ng notice dito sa mga registries natin is local, no? So sa Philippines lang. Pati nga yung mga publications natin, wala namang wala namang mga issues yan that are sent abroad. So pag nagpa-publish ka dito sa Philippines na let's say notice or a copy of your petition in some cases, dito na sa Philippines yan nagkaka-effect ng constructive notice. Okay, so anyway, so in this case, the complainants here were not in the Philippines at the time. They only learned about the fraudulent titling of the property later, no, much later. Kasi sinabi ng Supreme Court then to be fair and in the interest of justice, dapat yung 6-year period na yan, yung 6-year prescriptive period shall be counted. Number one, there should be the sine qua non, condition sine qua non, means the prerequisite condition na nagkaroon na ng title, a certificate of title. And then next is counted siya from the time of actual knowledge by the original title holder or the claimant of this new title. All right, and I'm done, ladies and gentlemen. So again, thank you very much. I hope you made it this far. So that has been my part 2 of the Land Titles and Deeds lecture for 2024. I hope marami kayo natutunan both from the part 1 and this part 2 video. Now, I know marami kayo mga questions. The first part also had a lot of questions. And of course, I appreciate the very kind words that you post on that video. So dito din, if you have questions, just comment down below. If you also have kind words to share to me, go ahead kasi nakakataba ng puso yan. And it inspires me to do more, to record more. So anyway, again, thank you very much. Please watch out for another video. I'm actually taking adoption. I'm also taking pointers in civil law for the purpose of the coming bar exams. So please tell me, tell me sa comment section anong gusto nyong maging next video ko. Okay? So again, thank you very much for watching. Again, this has been Attorney Al Jumrani. This is your favorite, sana nga, favorite na legal education channel on YouTube. Okay, this is the House of Law. So I'll catch you again next time. Please don't forget to like, subscribe, and click that notification bell. So again, till next time, laging tatandaan, isip ay buksan, alamin ang batas. Bye guys!